Morning and welcome to today's July 11, 2018 Maryland Public Service Commission meeting for the administration. Thank you, Commissioner Richard. Freshman fumble here. Good morning and welcome to today's July 11th administrative meeting of the Maryland Public Service Commission. Before we get started with today's consent and administrative agendas, let me just first say how honored I am to be sitting with my colleagues here today to serve on the commission, and how grateful I am to Governor Hogan to make the appointment. I'm humbled by his confidence in my abilities to lead this agency and its very important work. As you know, probably better than me, that the actions of this commission directly impact the lives of residents well beyond the rates that they pay for electricity and natural gas services. We have a public safety component, which I'm closely becoming familiar with, and we have a responsibility to ensure that our state's residents receive safe and reliable utility and transportation services. As a proud Marylander and resident of College Park, I'd just like to state that our residents should know how seriously I take the responsibilities of being the chairman of this agency, even more so as we enter a period of transformation to a number of the regulated utilities that we represent, whether it be taxi cabs and Uber or electricity services and the changes that we're seeing in the RTO and ISO markets. These are going to affect our lives in the very near term, and I think that Marylanders are going to be well positioned to receive the benefits of that change. Again, let me just say how excited I am to be working with my colleagues today and the very dedicated employees of the PSC, many of whom I met within the past few days. I'm also looking forward to working with our diverse regulated community, as well as other interested parties and the Office of the People's Counsel. I am hopeful and trust that we will engage in some very productive dialogue as we tackle the challenges that lie ahead in the near term. And I look forward to working with all of you. With that, I know we have some business. We start with the approval of the minutes. So I would ask for a motion to approve the minutes from the last meeting on July 3rd, 2018.
Mr. Chairman, I move that we approve the minutes for the July 3rd administrative meeting.
Thank you, Commissioner. Is there a second?
Second.
All in favor, please say aye.
Aye.
Any opposed? The motion carries and the minutes from the last meeting on July 3rd are approved. I would ask Madam Executive Secretary to proceed with today's consent agenda.
Thank you, Mr. Chairman. Today we have 7 items on the consent agenda. They are all revised tariff pages that were filed proposing to reduce terminating access rates pursuant to Federal Communications Commission Connect American Fund order. The companies filing those tariffs were number 1, CenturyLink Communications LLC, filed its tariff on June 13, 2018. Second was the Broadwing Communications LLC, filed its revised tariff on June 13, 2018. 3 is Global Crossing Local Services, Inc., filed its revised tariff on June 13, 2018. Number 4 is Level 3 Communications LLC, filed its revised tariffs on June 13, 2018. Number 5 is Level 3 Telecom of Maryland LLC, filed its revised tariff, tariff number 10. The prior one was tariff number 3. Filed that tariff on June 13, 2018. Number 6 is Telco Operations LLC, filed its revised tariffs on June 13, 2018, and MCI Metro, number 7, MCI Metro Access Transmission Services LLC, DBA Verizon Access Transmission, filed its revised tariffs on June 18, 2018.
Thank you. Do any of the commissioners have questions regarding any of the 7 consent items? No. Seeing none, do we have a motion?
Yes, good morning, Mr. Chairman. For items number 1 through 6, I would move that we accept the tariff revisions for filing with an effective date of July 18th, 2018. And for item number 7, I move that we accept the tariff revisions for filing with an effective date of July 31st, 2018.
Thank you, Commissioner. Do we have a second?
Second.
Thank you. All in favor, please say aye.
Aye.
Any opposed? In the opinion of the chair, the ayes have it, and the motion carries. I neglected to ask if any of my commissioners had any opening statements this morning before we proceeded to the consent agenda.
Mr. Chairman, I'll just say I think we all share in welcoming you to our bench, and we appreciate your leadership going forward as well. So I'm sure the rest of the commissioners echo that.
Thank you, Commissioner.
I would like to add as well, and we appreciate the first couple of days and the fact that you've hit the ground running and have been so active in not only meeting with staff, but meeting with us as well. So welcome, and we look very forward to working with you.
Thank you, Commissioner. Each of the commissioners have been very gracious in their time, allowing me to get settled. As well as former Chairman Hughes, I appreciated having the opportunity to meet with him before he departed and made the transition from himself to me as easy and painless as possible. So I do appreciate that. At this point, let's proceed to the administrative agenda, Madam Secretary.
Thank you, Mr. Chairman. Item number 8 is going to be deferred to July 25th, 2018. We move on to item number 9, Leventon Manufacturing Company filed on June 7, 2018. Request for electric submeter approval.
Good morning, Chairman, Commissioners. Michael Dean on behalf of staff. Item 9 is a filing by Leviton Manufacturing Company requesting approval of the Leviton Gen 3 mini meter models MSNC2-1SC, MSNCT-2SC, MDNCT-1SC, and MDNCT-2SC for billing use in Maryland. Under Comar 20.25.01.04a, an electric meters to meet the applicable provisions of the American National Standard for Electric Meters, ANSI C-12.1, and shall be approved by the Commission before being installed for billing purposes. The filing indicates that the 4 meters are intended as the next generation replacements for meters currently approved by the Commission that were manufactured by Integrated Metering Systems, a firm that has been acquired by Leviton. As discussed in staff comments, Leviton provided documentation to staff showing that the new meters meet the ANSI C12.1 and C12.20 standards. Based upon its review, staff recommends that the Commission approve the Leviton Gen 3 mini meter models MSNCT-1SC, MSNCT-2SC, MDNCT-1SC, and MDNCT-2SC meters to be used in submetering applications in Maryland. And I would lastly note there is a typo in the staff comments. The abbreviation for American National Standards has ANSCI. That should be ANSI.
Thank you for that presentation. Do the commissioners have any questions of staff?
Mr. Chairman, I have a few tough questions for Mr. Ratushny, if he wouldn't mind answering a few of my questions. Mr. Ratushny, do you intend to be on the beaches and ski slopes very soon?
Yes, and I invite you as well. And you will get free ski lessons.
I wanted to take this opportunity to say what a pleasure and an honor it's been having you work for this commission, and I know you're going to be leaving soon. I saw you standing there. I wanted to take the opportunity to express that publicly.
Thank you. May I have some additional comments to this?
Oh,
I do.
please.
Okay. I believe that Commission should consider to repeal these regulations for the following reasons. This regulation required submitter to meet NCC 12 requirements based on intent that it should be accurate. And NCC 12 required accuracy within 1%. And many submitters manufacture don't meet these requirements. And in order even to do test NCC 12, it's very expensive. It's around $200,000. So advantages of submetering will exceed variation of accuracy, like within 5%, for example, because many study shows that the conversion from master meter operator to submetering or energy allocation system would produce about 20% energy savings. So just this positive well overweight negative accuracy if it's not as accurate. In addition, you consider for electric vehicle charging station and all that used right now and utility propose their accuracy not meet NCC 12 requirements. It's within 5%. And probably possible implementation is as a submeter, consider them as submeters. And in addition to this, when I spoke to Delegate Washington, his intent was to make submetering energy allocation for master meter operators mandatory. So if that will be new law, it will make easier to implement this new law and provide more incentive to landlord to implement this.
Thank you for those comments.
Mr. Ratushny, if I might, does staff have a formal proposal for that regulation change?
I'm not aware. I have many of them, but it's still somewhere in stuff.
All right, well, thank you for bringing that to our attention. We appreciate it.
Mr. Ratushny, I also would like to express my congratulations to you. It's well earned. It's a loss certainly to the commission and to the industry, but at the same time, over the years, I've found you to be very helpful and very responsive to many consumers out there who needed someone from the commission just to be an ear for them, to explain information to them about how everything works in their house. And so you've actually been in the basements and in the houses and in the backyards and talked to people like that. So that's certainly not something that has been missed. So I just want to note that I appreciated that. But I also did want to ask a question since you're here. Could you tell us a little about some of the features that this type of mini meter would provide to the consumers that would see it or would be having their service measured through it?
It's one of the features that many provide, similar to smart metering.
Okay.
In most cases, they have hourly or 6-hour interval profile of energy consumption and ability to monitor it. And so consumer will make their decision based on their consumption, which is very good for submeters applications.
All right, so these are more advanced meters and not just another version of what we would call a legacy or meter from the years past.
Right. Actually, almost all lately approved meters are more advanced. They have communication device and they have recording and provide information to consumers about their energy consumption.
Great. Thank you. Thank you, Mr. Chairman.
Thank you. Any further questions of staff? Do we have a representative from the Leviton company with us today? It appears we do not. Any statements from Office of the People's Counsel if they're present today?
No, Your Honor.
Thank you. In that case, I would ask if there is a motion.
Yes, Mr. Chairman, I move we approve the Leviton Gen Mini Meter Models MSNCT-1SC, MSNCT-2SC, MDNCT-1SC, and MDNCT-2SC to be used in submetering applications in Maryland.
Thank you. Is there a second?
Second.
All those in favor, please say aye.
Aye.
Any opposed? No. The motion carries and the matter is approved. Madam Secretary, if we can move to the next item.
Thank you. The next item is UGI Central Penn Gas, Inc., formerly known as PPL Gas Utilities Corp., filed on March 13, 2018, notice of proposed corporate restructuring and name change.
Good morning, Chairman Stanek, Commissioners. Kenneth Albert on behalf of staff.
This item addresses a request by a Maryland gas utility, UGI Central Penn Gas, Inc., I'll refer to them as UGI, for authorization for a corporate reorganization in which UGI will be merged into its corporate parent, UGI Utilities. The merger involves the transfer of UGI's Emmitsburg gas franchise to UGI Utilities. UGI has roughly 530 customers in Maryland, and the customers are in Emmitsburg. The rest of UGI's customers, numbering up roughly 85,000, are in Pennsylvania. Under the Public Utilities Article, Section 5-202, the Commission will allow the transfer of a franchise if the transfer is in the public interest. UGI asserts that the merger is in the public interest for several reasons, including that the merger will result in increased efficiency in corporate operations by streamlining the corporate structure. The merger will not affect the services that UGI provides to its customers, and it will not affect their rates. Staff believes that UGI has demonstrated that the merger is in the public interest. Therefore, staff recommends that the Commission approve the merger, including the transfer of UGI's Emmitsburg franchise to UGI Utilities, with the condition that UGI file a tariff that reflects its new name of UGI Utilities, and that UGI notify the Commission when the merger is completed.
Thank you, Mr. Albert. Do commissioners have questions of staff? Commissioner Herman.
Mr. Albert, I was a little confused by this item. Because the way you just described it, it sounds as if this is really more of a name change than a merger or a transfer of a franchise. And I think, I'm confused as to, is there a change in control? Is UGI, CPG is currently the holder of the franchise, and CPG is being merged into UGI, I think is how it's working. And therefore, I'm wondering, is there a change in control that we should be looking at?
Well, yes, there is. I mean, this is a reorganization. To put it in perspective, you're dealing with a single corporate organization where they're reorganizing the way things are controlled. But technically, from perspective of, is there a new entity controlling this utility, that would be correct.
So why isn't this then a merger proceeding?
Well, that's a fair question, Commissioner. I actually looked at that. I mean, we were relying on a 2004 merger involving the predecessor of UGI, and in that instance, the Commission processed it under 5202 as a transfer of franchise.
Mm-hmm.
You could, I mean, I was thinking, frankly, just along the lines you have, isn't this looking under, if you look at 6101C3, arguably it could fit under that as well.
Mm-hmm.
Under that deal, C3 deals with, without prior authorization of the Commission, a public service company may not take, hold, or acquire any part of the capital stock of a public service company that operates in Maryland and is of the same class as the acquiring company.
Right. So let me explore that a little bit, because is UGI currently a public service company in Maryland?
Yes.
UGI is. It's not CPG, it's UGI?
Oh, I'm sorry. Well, I'm using different nomenclature, I guess. I'm referring UGI, you're referring to the parent company, UGI Utilities?
Well, I mean, this is really where I'm coming,
Sure.
is this a, is UGI currently, I get that CPG currently holds a franchise, so they're a public service company in Maryland. Is UGI a public service company in Maryland prior to this, assuming this event is approved, prior to this event this approval taking place?
Yes, and that I would refer you to 6101C2, which says in this, I hate to throw you around to different sections, but it always, you have this sort of linear chart we do in our minds here to see what bucket a transaction might fit in that would require Commission authorization. And C2 says in this subsection, a company controlling a public service company is deemed a public service company.
Right.
So that's my bucket. You could
I'm
say
with
sure.
you. Okay. So then, since UGI currently controls
CPG, yeah.
CPG, they are a public service company in Maryland.
Yes, they're deemed to be a public service company.
Okay, that's helpful. Now, who is do you understand the operation currently between UGI and CPG? Is there a board? Who is controlling the operations of CPG right now? Is there a board of directors, and who's on that board of directors? And is that going to change when they get merged into UGI?
I think the representatives of the companies here, I prefer to defer to them on that.
Okay, they might want to come to the table, because
Commissioner Herman, Henry Seelau on behalf of UGI Central Penn Gas.
Okay.
We have two representatives from Central Penn Gas, and this question would probably be addressed by Ken Murphy, Vice President Law for UGI.
Okay. You're welcome to sit down at the table if you like, if
That's
you're
fine.
more comfortable.
Good morning.
Good morning.
The UGI Utilities, Inc., UGI Central Penn Gas, Inc., and the third utility that we own, UGI Penn Natural Gas, all have separate boards, but they're the two boards of CPG and PNG are composed of the same people, and the same individuals also form part of the board for UGI Utilities.
Okay, so there will be a change in the board.
It will be a broader board, with more independent directors than is currently for CPG.
Okay, thank you. One second, I'm still trying to get my mind wrapped around this one.
And Commissioner Herman, as you do so, I just had
Sure.
just a background question here. Being new to the utilities in the state of Maryland, does UGI have any other utility franchises or services in the state aside from those in Emmitsburg?
UGI Utilities does not have any other franchises.
Thank you.
We have an affiliate, UGI Energy Services, which is a marketer broker in Maryland.
So, Mr. Albert, the public interest, because under either transfer of franchise or a merger, it would have to be in the public interest, but with the merger, it would also have, benefits and no harm potentially and that sort of thing. Is the public interest, has staff looked into, is there, what you've said is that it's, more efficient operation of the company and that sort of thing. Have you had any kind of quantification of that? Do you know what the effect of employment is going to be? Are we going to, have some of the current employees get moved or, lose their jobs? Are we, what else do we, what other information do you have, if any, on this?
I mean, I think we looked at it, we get a lot of reorgs, a lot on telco side, unusual to see it on the utility side, but generally speaking, it's presented to us as being in the public interest because of a streamlining. It's going to make the corporate structure more efficient, reduce costs because they have that many less entities out there that they have to round up. For more specific questions, I would defer to the CPG on exactly the impacts of employment and otherwise.
Okay. Are there any impacts on employment in the state?
In the state, no. In fact, this is not being viewed as a merger of, say, two independent entities that have two sets of management and two sets of administrative staff. Currently, the administration and management is performed mostly by UGI Utilities employees through agreement that has been approved by the Pennsylvania Public Utility Commission. Officers are generally the same individuals. So when the efficiencies come to play is mostly associated with elimination of the separate corporate form. We're going to have fewer filings to be made. Where we do 3 now in Pennsylvania, we'll be doing 1, that sort of thing. Tax forms, it'll be under UGI Utilities as opposed to income tax forms for each of the 3 businesses. At the same time, we're investing a considerable amount of capital in improving our customer information system, our accounting systems, and so those are going to allow people in the accounting function who are no longer going to be needed to allocate costs between 3 different businesses are going to be freed up in order to adapt to the new financial systems, which will help improve our accounting processes and things like that. So we look at this as an opportunity for some employees to actually improve the functions that they're performing.
Okay, and will there be an office located in Maryland?
I don't believe we have one now.
I don't believe there is an office.
Okay, because I believe to be a public service company in Maryland, you need to have an office for service?
Well, we do have a mailing office, but we don't have a set of employees here. I believe they actually operate out of an office just across the border that serves Pennsylvania customers as well.
So we probably have that already covered some other way. Okay. And, Mr. Albert, one of the discussions was that new tariff pages that were going to be filed were going to be just with a name change. And so I noticed that in the filing it says that rates, services, and facilities are going to be the same. Are the terms and conditions going to remain identical? Because Maryland obviously has
Yes.
different terms and condition requirements than Pennsylvania. So would you be assuming that the tariff changes will be name changes?
The name changes only.
Okay.
Yeah, the cover page and the band across
Sure.
the top of each page.
Right.
Yes,
And usually on the bottom too sometimes.
yeah. Yep. Sometimes.
Okay. I think that's all I have for now. I'll
Right.
see if anybody else has questions.
Can you tell us what is the status of your joint application before the Pennsylvania Utilities Commission?
We filed, I believe, March 9th, and that started a notice process through the Pennsylvania Bulletin, inviting people to comment and file protests, complaints. There's 7 parties in a proceeding before an administrative law judge of the Pennsylvania Public Utility Commission. We have reasonable optimism that within the next few weeks we'll be settling that proceeding, and we're hopeful that we can get what is known as a recommended decision from an administrative law judge sometime in August, then a final order from the commission in September, so that we can close in October 1st.
So if the commission grants your application petition today, that would be subject to the Pennsylvania Commission approving your joint application?
Yes. The 2 items required for us to close are the Maryland and the Pennsylvania Commission orders. We have 2 lesser proceedings before the Federal Energy Regulatory Commission associated with a pipeline that crosses from southern Pennsylvania into Maryland. It's a Section 7F proceeding for Hinshaw Pipelines that receive and obtain their gas. The pipeline crosses in FERC has jurisdiction under Section 7F. And then there are items called Order 63. It's an obscure proceeding under the FERC regulation for a Hinshaw pipeline to provide interstate services. And because part of Central Penn Gas and part of Penn Natural Gas are located in the Marcellus Shale, we actually gather gas for producers and then push that into the interstate stream, which can go into pipelines such as Transcontinental Gas Pipeline. And that gas, and once it enters the interstate stream, makes that function FERC regulated. And so we're in the process of obtaining those approvals and believe we'll have those by the end of the summer.
Thank you. Do commissioners have additional questions? Commissioner O'Donnell.
I wanted to ask staff first. You mentioned a previous proceeding that was treated differently than this one. Is that correct? Treated as a 502 merger?
I would put it differently. I think what the question from Commissioner Herman in terms of finding what bucket of commission jurisdiction, the question was, why did you pick the transfer of as a franchise transfer rather than as an acquisition under 6101? And I think what drove the staff's position there was we looked at this prior precedent involving the predecessor of CPG, and that was a 2004 decision where the commission did process it as a transfer franchise. And staff is sort of a creature of habit here. We looked at this and said, that's how the commission wants to process it, and we actually specifically referenced that case. What I was saying, Commissioner Herman, my understanding is arguably an additional jurisdictional bucket would be under 6101C, perhaps the more substantive transfer of ownership control of a utility. In this instance, of course, a gas utility.
Okay. Let me ask the company this then. Your Pennsylvania proceeding, is it considered an administrative level proceeding before the PUC up there, or is it considered a more robust transfer of franchise and ownership in Pennsylvania? And here's the reason I asked you this. When we do larger merger proceedings, multi-jurisdictional, we put things in there typically like most favored nation clauses and many other things because we don't cede our authority or want our citizens treated differently than maybe they would be treated under the same acquisition or merger in another jurisdiction. In other words, we typically make sure our citizens, our constituents or ratepayers get treated equally fairly by the merging entities. So how is this proceeding being treated before the Pennsylvania Utility Commission?
There is an administrative proceeding whereby UGI Central Penn and UGI Penn Natural Gas, who are certificated public utilities in Pennsylvania, those certificates will be will be terminated, and then UGI Utilities will acquire those service territories. The gist of it is we believe these are form and substance of an internal reorganization because UGI Utilities, Inc. is the 100% equity owner of CPG and PNG, so there is no real change in control. We already, as UGI Utilities, have control over these businesses.
Might the PUC in Pennsylvania attach conditions or terms to that proceeding that may say you have to provide certain specified benefits that might offset other
I
concerns?
suppose that they have the authority to do that. As we have proposed, there are conditions relative to the nature and types of record keeping that we will maintain. Under the rubric that we've put together here, the former UGI gas business, the UGI Central Penn business, and the UGI Penn Natural Gas are going to be rate districts within what is known as UGI Gas. All the terms and conditions applicable to those tariffs of the former subsidiaries are going to be incorporated into the UGI Gas tariff, lock, stock, and barrel, no changes. That's the proposal. And there has not, in the testimony that was served yesterday in Pennsylvania, nobody's asking for any real changes to that. Broader record-keeping requirements than we had proposed, but nothing that we are all that upset about.
So no contested proceeding in Pennsylvania?
Well, it is contested at this point, but we're hoping to resolve it fairly quickly.
Okay. All right, thank you, Mr. Chairman.
I have one quick question, but Commissioner, do you have a question?
I would just to clarify, so this restructuring, would it or would it not change in any way this commission's ability to look out for the interests of these 500-plus customers?
No, not at all.
It doesn't?
I mean,
Okay.
clearly the commission's jurisdiction will continue. Instead of CPG, it's now going to be a different
Okay,
named
good.
entity.
So I read correctly that, approving this today, really, we can still do our job at this commission and look out for these.
Right, there's no impact on the commission's regulatory authority.
Perfect, thank you, that's all I needed to hear.
I recognize that UGI Central Penn Gas filed its application with us back in March of this year. Is there any time sensitivity with respect to our action on this application, either today, or are there any deadlines that are coming up by which you need a response from this commission?
The time sensitivity is related to our fiscal year, and what we're hoping to do is to close this close the merger in time so that we can start our new fiscal year as a merged entity.
When does your new fiscal year begin?
It would be October 1st of this year.
If this commission needs additional time to review this matter, would it pose any burden on the company if we took another 2 weeks to review?
The burden is just uncertainty, Chair. We're trying to move this towards a certain phase so that we can get the resources together to make sure that we have all the T's crossed and I's dotted in order to close the transaction.
Thank you.
Can I ask another question, Mr. Chairman?
Please.
So I don't want to jump ahead in the agenda, but I have to ask it now before we take any action. The next item on our agenda is the Tax Cut and Jobs Act implications for the company. Does item number 10, this change in corporate structure, have any impact on item number 11, or vice versa? Because I need to know that before. I need to know that now while we're still on number 10.
Commissioner, okay, I'm being advised. I did not work on the tax cut flow through. I've been advised by the attorney that was working on that there will be no impact.
No impact one way or another to where the monies are going or how they're divvied up as a result of the Tax Cut and Jobs Act. No fiscal implications whatsoever.
The Tax Cuts and Jobs Act will. I'm Janice Flynn for the next item. The staff is recommending, and the company agrees, we're flowing the benefits of the Tax Cuts and Jobs Act through rates. The rates, as been the company stated, are changing the same, are not changing. Will have the same terms and conditions. So this should not have any effect on our recommendation in the following, whether or not you approve the merger.
So if we delayed this, as the chairman was asking about number 10, and we approved the other one, or if we approved both, or we approved both together, there would be no impact one way or the other.
There wouldn't be any impact on our recommendation for the change in the rates.
I'm not
We
asking
would.
impact on recommendation, I'm asking on impact on the ratepayers, actually, where the money goes.
No, there will be no impact.
All right, thank you.
Thank you. Any further questions, Commissioner Herman?
Mr. Albert, after hearing about the board composition from the company, do you have an opinion? Do you think this is now potentially a merger or change in control now that the board's going to change?
It could go in that separate. Arguably, you could view this as a transaction that requires approval as a transfer of a franchise. And again, I sort of had the same thought you did, which is arguably this goes under what might be a more substantive bucket under 6101C of change in ownership of a public utility. So
Right.
I think, I mean, I think the company's point, which is a valid one, is this: we're saying, hey, this is just a reorganization. Still, the top dogs are still going to be the top dogs in this company. CPG will just be now merged into another entity, but within the same corporate family. But yeah, I think that to me is the key thing. But yeah, as far as which bucket, staff, I think, was driven by the fact that this is how the commission processed a virtually similar transaction in 2004. But arguably, you could choose two different hooks for approval for this transaction.
Thank you. Mr. Silo, you have a comment on that?
Yes, Commissioner Herman and Commissioner O'Donnell, because you both posed this question. I want to point out that in 2008, when PPL, the 2004 transaction that was referred to, involved the predecessor entity, PPL, that merger, and that's what happened. Then in 2008, when UGI acquired PPL, we went through the full 6101 proceeding to go through all of this, and that looked at the ultimate entity. It answered all the questions involved in that at that time. So as a corporate entity as a whole, UGI has been through this already. And we then referred to the 2004 entity, which was, and by the way, PPL went through that as well, because this was Emmitsburg Natural Gas, owned by South Penn, then owned by Penn Fuel Gas, then owned by PPL, then owned by UGI. So we went through each of these steps, but we also been through the corporate reorg before, when the commission elected to treat it as a transfer of franchise. And then subsequent to that, we had the full-blown merger look when UGI took over that looked at all of the UGI entities. So we've done that at one point.
Okay. Thank you.
Any additional questions? Before I ask for a motion, I would ask if any commissioner would wish to table this item for additional consideration.
Mr. Chairman, because I want to make sure, I want the company to understand that it's not a concern with, with UGI or the company, the way it operates, but I feel it's important that we make sure that it does go in the right bucket, as Mr. Albert discussed. So I'd like a little bit more time for our council to help us understand you make sure we're putting it in the right bucket. So that would be the reason why I would like to take a little more time with this item, Mr. Chairman.
Thank you. Do any commissioners oppose the request of Commissioner Herman?
I don't oppose the request. I would be interested to know and understand what information are we looking for between these buckets. I mean, these are all the same affiliated companies. There's really no change, no new characters that are coming forward. We're not going to be changing any of our authority to look out for the citizens. There is a geographic reality to this location, and the fact that there are only about 500 or so consumers. I just would like to understand, throwing this into some uncertainty, business uncertainty, what is it we're going to gain with this extra 2 weeks?
I'm just looking for precision to make sure that we legally put it in the correct bucket where it belongs, and that we grant it, and that we do the appropriate review based on which bucket that it goes in. And therefore, again, I'm not holding this up from a substance standpoint, but I do believe it's important that we make sure that we conduct the appropriate review and issue the appropriate order with the appropriate findings based on the correct classification of this transaction.
Mr. Chairman, I'll weigh in. My sense is that this item is okay, but usually I'm the one on the commission, or often the one, asking for more time for consideration and the chance to gain some degree, some level of comfort with an item that has some questions that still reside in my mind. That being the case, October 1st is the new fiscal year. There's no urgency. There's no time sensitivity to it, and I'm in favor of allowing one of my fellow commissioners to gain that level of comfort, and I think we shouldn't be afraid to do that. So that's my opinion.
Mr. Chairman, thank you. I would also agree. I had some concerns about some of the information that we have and do not have as part of the original filing. I think some of the questions that have been raised today help to clarify some of that for me, and I think in the long run, I think this would probably be fine. I would like to see some clarification for Exhibit B in the report, the filing that the Commission staff presented, which is basically just a work chart, but I think that we've heard today that all of this is happening within one corporate family, and there's clearly some history about how the corporate family came to be where it is today. But I think that a document like this exhibit would give us a little more understanding as to who's moving where and what's going to happen as a result of an approval by this commission. So that's at least one piece of information that I think would be a little helpful.
Thank you, Commissioner. Based on the comments of the Commission and also noting Commissioner Richards' position, what the Commission will do at this point is grant a brief continuance here for 2 weeks, and we will take this matter up again at the July 25th, 2018 administrative meeting if that meets with the satisfaction of the Executive Secretary.
And just to be clear what my position is, I will also always support, generally support a commissioner's request for additional time and provide that courtesy. So that is my position.
Thank you. Thank you. The next matter up, Madam Secretary.
Yes, Mr. Chairman. The next item is UGI Central Penn Gas, Inc., formerly known as PPL Gas Utilities Corp., filed on June 20, 2018, supplemental filing in Gray Mail Log 219037, the impact of the Federal Tax Cuts and Job Acts of 2017.
Good morning, Chairman Commissioners. Janice Flynn for item number 11. UGI has filed tariff revisions that are designed to flow benefits of lower federal corporate tax rate from the Tax Cuts and Jobs Act to ratepayers. In response to the Commission's order in case number 9473, on February the 15th, UGI filed a proposal that sought to decrease current rates to account for the effect of the Act on operating income, but failed to account for the savings associated with the excess accumulated deferred income taxes or the regulatory liability that has accrued from the date of the implementation of the Tax Cuts and Jobs Act to the date the new base rates are implemented. Staff has worked with the company since that time, and on June the 20th, the company filed its supplemental filing that is before you now. The supplemental filing included revised tariff schedules that staff believes accurately account for all savings associated with the Tax Reform Act, including the excess ADIT. UGI calculated a reduction in operating income of $29,000, which results in a $40,902 decrease in the revenue requirement. In addition, excess ADIT will result in total tax savings of $1,254. UGI supplemental filing also accounts for the tax savings for the period from January 1 to July 31st, July 31st being the proposed effective date of the revised tariffs. This amount we refer to as the regulatory liability is estimated to be $16,721. The company plans to discharge its regulatory liability for this period in the form of a one-time bill credit to all rate classes. The company estimates that the average residential customer will receive a one-time credit of $6.86. The company should be directed to provide an informational report to the Commission after the one-time credit is completed to disclose the actual amount of the refunds made. Staff has two corrections to make to its comments. Mail Log 220987, which is at the top of the comment, should read 220984. And we're sorry for any inconvenience this typo caused. In addition, page 4 of 7, the last paragraph, the regulatory liability is noted as 16,271. Those numbers were transposed. It should actually be 16,721. and that same error should be corrected in the first paragraph on page 5 of the staff comments. With regard to the allocation of these savings, staff has allocated the savings entirely to the distribution rates because UGI does not have a customer charge. Staff based its allocation on UGI's 2015 distribution revenue. We note the company has not filed a base rate case since 1979, so staff chose the most recent year with normal weather, which was 2015, to make its allocations. We also note that the company serves its transportation class under contracts. The transportation class contributes a significant amount of total revenue to the company, and the company plans to amend the transportation contracts to account for the tax savings. Staff recommends that the company provide executed contract amendments as soon as possible after all the contracts have been signed. So staff's recommendation, therefore, is as follows. We recommend that the Commission authorize UGI to implement revised rates as proposed by staff in the company's June 20th filing and accept the tariff pages for filing. Direct UGI to file clean tariff pages with an effective date of July the 1st, 2018. Authorize UGI to implement a one-time refund related to the 2018 regulatory liability and provide an informational report to the Commission not more than 60 days after the refunding process is complete. Direct the company to file amended contracts, including the authorized rates, and direct that if additional tax savings are identified but that were not addressed in UGI's previous filings related to the Tax Cuts and Jobs Act, the UGI be required to make a filing with the Commission to return those savings to customers as soon as possible.
Thank you, Ms. Lynn. Do any of the commissioners have questions on this matter for staff?
Just to clarify, I have a degree of comfort with the last provision that you stated, Ms. Flynn, which is any identified tax savings going forward will be returned to the customer. So if there was an impact on the item that we've deferred for further consideration, it would be taken care of under that clause. So I have some degree of comfort on that. Thank you.
Do I have a motion for this item?
Okay, Office of People's Counsel.
Oh, one moment. I apologize. Office of the People's Counsel, please introduce yourself.
Thank you, Your Honor. Anna Ryan for the Office of People's Counsel. As you all know, the TCJA has created some unique circumstances and some challenges for companies trying to determine how much benefit from the TCJA to pass back to customers and how to allocate those benefits. And one of the challenges has been that when it's been a long time since a company has been in for a rate case, there isn't necessarily up-to-date data in order to use to make those determinations. And OPC has been advocating for companies that have had a length of time since their last rate case to come in for a full rate case in order to give us the most up-to-date information. However, we have another unique circumstance here with UGI, and in this case, given the small number of customers that UGI has in Maryland, the cost of a rate case would be an undue burden on those customers. And so in this case, we do support staff's recommendation. We find their methodology to be reasonable, and so we would be in support of the methodology used in this situation. And I would also like to add that we do concur with staff's conclusion that the previous matter, whatever action the Commission takes on that previous matter, would not have an effect on ratepayers.
Thank you. Any questions for the People's Counsel? Thank you. We have UGI in the room. Do we have any questions for the UGI representative? None. Thank you.
I want to take this opportunity, and didn't get to do it earlier, to welcome you to the Commission, Chairman Stanek, and to thank the Commissioners for your questions.
Thank you, Mr. Silla. At this point, I think it's safe to ask for a motion.
Mr. Chairman, I move the Commission authorize UGI Central Penn Gas Incorporated, UGI, to implement revised rates as set forth in the company's June 20th, 2018 filing and accept the tariff pages for filing with an effective date of August 1st, 2018. Authorize UGI to implement a one-time refund related to the 2018 regulatory liability and direct the company to provide an informational report to the Commission not more than 60 days after the refunding process is complete. Direct the company to file amended contracts including the authorized rates, and finally, direct the company to make a filing with the Commission if additional tax savings are identified but not addressed in UGI's previous filing in this matter related to the Tax Cut and Jobs Act of 2017, to return those savings to customers as soon as possible.
Thank you. Do I have a second?
Second.
Those in favor?
Aye.
Those opposed? In the opinion of the chair, the ayes have it, and the application is approved.
Thank you.
Next item, please, Madam Secretary.
We can take the next two items together. Item 12 is Edward Crooks, filed on April 19, 2018, a request approval to transfer ownership of Hawthorne Water Supply, Inc. And item 13 is Edward Crooks, filed on June 1, 2018, a request for approval to transfer ownership of Charles County Gardens Water Company.
Michael Dean again for staff. Items 12 and 13 are filings by Mr. Edward Crooks requesting approval of the transfer of ownership of the Hawthorne Water Supply System and the Charles County Gardens Water Company, both of which are located in Charles County, to Mr. Crooks. Under Public Utilities Section 6-101 and 5-203, prior Commission approval is required for transfer of stock or other ownership interests in a public service company, which is typically done on a public interest basis. Section 5-201 requires Commission authorization to exercise a water system franchise, and Section 5-202 requires prior Commission authorization to transfer a water system franchise. Public Utilities Section 1-101 SS defines a water company as that owns as a excuse me, let me start over again. Public Utilities Section 1-101 SS defines a water company as a public service company that owns a water plant and sells or distributes water for gain, and the definition of public service company in Section 1-101X includes a water company. The Hawthorne Water Supply System dates from approximately 1960 and is currently owned by its 12 customers who set rates to cover expenses. The unmetered system is maintained and operated under an agreement since 2011 by Water Services, Inc., a company that is owned by Mr. Crooks. The Board of Directors of the system approved the transfer of ownership of the water system to Mr. Crooks on a as-is basis for $1, and information concerning the transfer was discussed with the customer owners at their annual meeting on May 31, 2017. Following proposes a rate of $54 per month per customer, which is less than the current charge, and as staff discussed in its comments, there is some support of the charge was provided in discovery. The Charles County Gardens Water Company dates from approximately 1960 and is owned by its 89 customers who set rates to cover expenses. The unmetered system was also maintained and operated under agreement since 2008 by Water Services, Inc. The agreement for transfer is an as-is basis for $1 and was voted on April 25, 2018, with 55 of the customer owners voting for the transfer and 1 against. The following proposes a rate of $30.83 per customer per month and was reached by agreement with the current customer owners, and as discussed in staff comments, support for this rate was provided in discovery. As both water systems currently set rates to recover costs and do not sell or distribute water for gain, they do not meet the definition of water company under the Public Utilities article, and thus the systems would not qualify in their current form as public service companies. In addition, Charles County does not grant franchises to water companies. Since Hawthorne and Charles County Gardens are neither public service companies nor operate under franchises, prior Commission approval is not required under the terms of the statutes for transfer of the ownership of these water systems to Mr. Crooks. However, as noted in staff comments, it If the Commission wishes to approve transfer of ownership, it may do so by finding that the transactions are in the public interest, which they are since Mr. Crooks has agreed to become responsible for the operation and maintenance of the two water systems. Mr. Crooks currently owns and operates 9 other small water companies, and the Hawthorne and Charles County Gardens are located near the companies he currently owns. The Commission has previously approved 2 similar transactions involving the transfer of ownership of water systems to Mr. Crooks. In 2006, by order number 80511, the Commission approved the transfer of the Tip Hill Water Company, and in 2017, by letter order, the Commission approved the transfer of the West White Plains Water Company to Mr. Crooks. Similar to these transactions, staff is proposing that the initial rates for the Hawthorne and Charles County Gardens be approved on an interim basis, and if approved, the 2 systems can be included in the current review of rates being conducted by the Accounting Investigation Divisions using the simplified rate procedure for small water companies. Based upon its review of the filing and discovery request, staff recommends that the Commission note the transfer of ownership of Hawthorne Water Supply to Edward Crooks and accept for filing an interim rate of $54 per month per customer. Staff also recommends that the Commission note the transfer of the Charles County Gardens Water Company to Mr. Crooks and approve an interim rate of $30.38 per month per customer.
Thank you, Mr. Dean. Excuse me. Do the commissioners have questions? Commissioner Richard.
I just wanted to ask a question about these interim rates. When I guess the customers for both of these water systems went into these negotiations, were they aware that the rates were just going to be interim, the $54 and the $38.38?
I would say no is the response to that.
So they went in with the belief that they were negotiating a rate. Do we, again, you haven't done the study yet, but do we expect any major changes in those rates? In other words, is this a case where maybe we want to delay until we have a firmer handle on what those rates are going to be to see if that would, again, impact the decision of these customers?
I'll let the accounting division answer that.
We do have an ongoing investigation involving Mr. Crooks's other companies in the simplified proceeding. It's difficult to, I guess, state with authority what the end result of that process will bring. Today I believe that the rate on the table offered by Mr. Crooks is a reasonable rate. I have nothing to say that it would be an unreasonable rate. It was going to be our plan to roll these 2 companies into our current investigation, and if something happens to, we would roll that forward. It's our plan that the investigation should bring a result probably around October or November.
Okay. But in any case, at this point, you stand by the recommendation that we just go ahead and proceed, given, again, that these residents may not have been aware that they were not being locked into a rate, but in fact would be subject to a different rate.
I think the key point is the residents know that the rate that they're going to be charged. Mm-hmm. And I think in the case of, it was Hawthorne, I believe, it's a significant decrease to what they are being charged currently. So that's key. I can't state the same for, I don't know what, is it Charles County? The one that's being charged $30. I don't know what they're being charged currently by Charles County Gardens. But it's, for other companies in the state of Maryland, the proposed charge is not unreasonable to what those companies are charging.
Okay, so that the reasonableness is behind your recommendation, then why we should go proceed with this. The other question I had was, looks like this Mr. Crooks is becoming a water company of sorts. I mean, he's got now 10 systems. Are they all in Charles County?
There's some, I believe there's some in Culver County as
Culver
well.
County, okay.
But most of them, the bulk of them are in Charles County.
And I guess where I'm going with this is there was a law that was passed recently that creates a single tariff pricing regime, rate consolidation. Would this enable Mr. Crooks then to consolidate all these different companies and potentially do a major, I guess, capital project in one area, and then which of course would have the impact if this law applied?
Well, it's an interesting point. These are 11 or 12 individual companies, corporations, that are, some are at a significant distance. It is something that he could use to his advantage and try and bring about economies of scale and hopefully bring about some savings to customers.
So you overall would think this would be a savings, a benefit
difficult-
to customers,
it's
rather
difficult
than,
to
again,
say.
if he did a major project for one of his 10 systems, I guess 9 systems, that would mean all the 9 systems would have to pay for it. So
Well, that's-
we're pretty certain that this is I guess, is this something that, again, these residents should be aware of?
The single tariff pricing?
Yeah, that this is on the table now, and that, if I'm hearing you correctly, you think that Mr. Crooks would benefit from this
Well, I don't-
new law, or benefit, or could apply this new law?
I don't know how a single tariff pricing would affect the prices across the board for the 12 individual companies. It's over the past year, Mr. Crooks has been doing wholesale. He's been putting in a lot of infrastructure to upgrade numerous parts of the companies. One of the advantages of a single price across the all of the companies would be, you're flowing that across everyone. It has advantages and disadvantages. One of the things that we would have to do is look at how it impacts each individual company, and it's difficult to say right now what that is going to turn out to be.
Okay, so ultimately that would be the commission's decision as to how these rates would be applied if Mr. Crooks were to use this new law.
Certainly, on a moving forward basis, if he applied to use a single rate, in my opinion, I think he would have to bring results for each individual company, and then we would have to look at it. What are the results on a consolidated basis, and then maybe move towards, maybe phasing in a result if it results in a disadvantageous result for certain communities.
Okay. I believe I'm comfortable with the recommendation, but, maybe going forward in these, Mr. Alford.
Good morning, Commissioner. Juan Alvarado for staff. I just wanted to add a couple of things that might further ease your mind. The first thing is that in order for the company to come in for a single tariff pricing, there has to be a case. So before any of this happens, the Commission is going to be able to look at these rates and ensure that they're just and reasonable. The second point that I would like to make is that obviously staff is going to make a recommendation because he is under the simplified proceeding. Staff is going to be the one that's going to be looking at these rates. As with any other case, we are very sensitive to rate shock, so I wouldn't expect large increases to rates, which is why the going-in rate is so important, and why the fact that the going-in rate is lower than what they're currently paying says a lot about how customers are going to feel with regards to future rate increases. And then the last thing I want to say is that the single tariff pricing is designed for many reasons, but one of the primary ones is to actually aid companies that are really, really small. Particularly, we have a company that has 12 customers. If a tank breaks and the tank costs $5,000 to replace, 12 people paying for that tank is a huge burden that they cannot pay for. And this is the problem that we kept having with other really, really small companies. So the reason why we introduced single tariff pricing is because if you throw those 12 people in with a much larger group of customers, then that $5,000 tank becomes, maybe a couple dollars a month at most instead of $600 a year. And so, maybe those three things will help ease your mind. I think that these rates, going in rates, are very reasonable. And then once we decide to increase those rates or to go to single tariff pricing, you will have full ability to look into those and make sure that they're just and reasonable.
Great, thank you. That was very helpful, Mr. Alvarado. No more questions.
Any additional questions?
Yes. I wanted to ask staff, if these companies are currently operated like co-ops, are they akin to co-ops, or customers are the owners of these small companies? Is that how it works?
They're more likely to be considered non-profits.
Yeah, I think co-ops are nonprofits. But, okay, and so they approved this transaction. The owners, the 24 owners of Hawthorne and the 89 owners of the other company approved this transaction, right?
Through their ownership structures, yes.
So they have, by virtue of them being the owners of the company or the assets, they have to know what this proposal is and what it means, right?
Yes.
Okay. I just want to make sure of that. Going forward, since these current entities are not regulated utilities because they don't sell water for gain in the state of Maryland, will Mr. Crook's companies, I will assume, will be regulated going forward, right?
Yes, they will be.
So will they have to, will he have to file additional fees for these entities, or will they come under his current filings with the commission? How's that work?
He'll be responsible for all the public service requirements. He'll have to pay fees to the commission. He'll have to file an annual report. All the things attendant responsibilities for a public service company, he will be responsible for.
So these entities will maintain their current name, and they will be separate entities filing with the commission, or they come under the current filings, or how's that?
Well, each what does he have? 10 or 11. Each one is a separate legal entity that he owns, and they all pay their respective fees to the commission. They all file an annual report with the commission.
Okay.
These new companies will follow in the same process.
Okay, and remind me, Mr. Alvarado, you may have to help me out on this. Wasn't it House Bill 528 that just passed this session, sponsored by Delegate Jameson, that created this single tariff for these water companies?
Yes, sir.
Okay, and she's from what county?
She's from Southern Maryland. I don't remember the county. I think
Charles.
All right, then great.
She's retiring this year, by the way, so I just had to give her a shout out. So. Okay, very good. Thank you. I appreciate it.
Any further questions for staff? No. Would you please identify yourself?
Yes, Mr. Chairman, Gary L. Alexander, on behalf of the Office of People's Counsel. Welcome aboard.
Thank you, Mr. Alexander. What is the People's Council's position on this matter?
We support staff's recommendation. We have gone through, I've gone through all of the pages, including back to 2004, and we believe that staff's diligence is sound. And if I understand correctly, staff is already conducting a review of rates under the simplified rate procedure, which was, as mentioned, HB 258, Chapter 190. And the only thing, just for clarification, that if I'm understanding correctly, Mr. Crooks will be the owner of the water companies, but then they'll be serviced in essence by his corporation, Water
Services Incorporated.
Yes,
That
Water
is my
Services
understanding.
Incorporated. And he also stated in his applications that the only increase in charges or rates would be if he invests in improvements in the the water supply.
Thank you. That is my understanding of the applications. Is Mr. Crooks or a representative from Water Services Incorporated in attendance? I do not see any. Any questions for the People's Council representative? None. In that case, I would ask for a motion on both items 12 and 13.
Mr. Chairman, for item number 12, I move we note the transfer of ownership of Hawthorne Water Supply, Inc. to Edward Crooks and accept the filing an interim rate of $54 per month per customer. Item number 13, I move we note the transfer of ownership of Charles County Gardens Water Company to Edward Crooks and accept for filing an interim rate of $30.38 per month per customer.
Thank you. Do we have a second?
Second.
All in favor of these two applications, please say aye.
Aye.
It appears that the ayes have it, and the motion carries. Is there any other business to be brought before the Commission today?
There's no further items on the agenda.
Thank you, Madam Secretary. In that case, this meeting is adjourned.